involving the rendering of legal advice, whether it's related to coverage issues or obligations under claims handling regulations or obligations to satisfy the good faith standard under case law. But there is legal advice going on there. And Mr. Aaron suggested that maybe we haven't even met the threshold burden of showing that there was an attorney-client relationship. Well, that's never been an issue here. Mr. Hall was retained by farmers to give them advice. He may have done other things too, and he's perfectly within the purview of the attorney-client relationship to do those other things. And I'm not, and neither is farmers, claiming that simply because an attorney was involved, everything that the attorney touches or every issue that the attorney's name appears on is privileged. But to the extent there is, from the lawyer to the client or the client to the lawyer, relating to the rendering of legal advice, that is privilege, and the Escalante Court recognizes that that privilege exists. On that issue, I do want to address the whole notion of fiduciary relationship or a fiduciary duty.
Counsel, before you do that, I want to follow up on Justice Alexander's question because there are so many documents here over the entire course of the claims adjustment process, which only was a year. It's hard for me to believe that every time it's just as counterintuitive. For example, I see here in the privilege log, there's an entry on No. 6. Now and it's attorney-client privilege. It's really hard for me to imagine that somebody's asking for legal advice on the day of the fire before a farmer says the fire was even reported. That's just one example. There are many, many places here. How short of an examination, how is anybody to know or to have any confidence that all we're talking about here are true communications? Information from the client to the lawyer, advice from the lawyer back.
I think there is any way besides an in-camera review to get that information. And the Escalante test and the way that Barry applies that
they'd have to answer
is designed to ensure that such an in-camera review is available.
So your position would be there's not a prima facie showing fraud, then log, and the answer is trust me.
No, I don't believe it's a prima facie showing of fraud. And that's one issue that I do want to bring up to the court now. In preparing for this argument, I read the Court of Appeals decision closely, more closely than I did when I first got it. And I do think that the court may have confusingly, inartfully, wrongly articulated the first prong of the two-prong test set forth in Escalante. You'll recall in the